Hello and welcome to the Goal Podcast, news and commentary from Gun Owners Action League, your leading voice for the Massachusetts gun owner.
I'm Garrett across the table from Jeff. Happy summer.
Yeah, officially. Well,
you wouldn't.
Is it official?
A couple more days. You wouldn't know it by looking around outside, though. I mean, we're supposed to have some hot weather this week, but it's been kind of gross generally.
No, but, you know, the plants will take the water.
Yeah, they're happy for it.
Some pepper plants and some herbs and stuff in the backyard that are hanging in there.
That's what I sent you guys, that joke picture. We planted a couple of your skull caps in my garden. I'm like, these things have been in here for months, and they haven't sprouted a single deer.
Started growing.
So what's shaking? We got a lot to talk about today, but what's going on?
Well, we got a busy weekend coming up. So this weekend is the fourth annual Tee It Up for Vets golf tournament.
I'm looking forward to that.
We've played in it a handful of years. It's over at St. Anne's Country Club. It's put together by some amazing folks. Our contact is Amy Stepka. It's absolutely great. Saturday, June 21st, St. Anne's Country Club. You, myself, Mike Harris, and Danny Hagan are going to go.
Yeah, go do some damage to the green. We got
go horrify a greenskeeper.
We got rained out last year.
I know. We were on a good clip. It was you, me, Mike, and Greg Wilkes from USCCA.
Yep.
And we had a good run going. We were doing okay.
I think we were doing okay, all things considered.
Well, you know, we weren't doing the typical golf scramble thing of just making numbers up, but
you mean the tournament guys that come in 24 under par?
But no, it's a good time. It's a great tournament. The course is really nice. The facilities are great. It's a great charity, great event.
It's a good cause too. So yeah, the last couple of years, Goals actually sponsored a hole, which is good. Which is great.
Yep. So we'll be there. Might have some podcast patches in the truck, and we're gonna go tear up somebody's lawn.
Job security for the greenskeepers. So you brought this stuff in, and we don't get paid by these guys or anything like that.
No, but if they wanted to sponsor it, I'd say yes.
I wouldn't say no. So you very generously supplied me with a bottle of this stuff, this Heaven Hill Kentucky Straight Bourbon Whiskey. It's actually pretty good. For a guy like me that doesn't drink a lot of straight alcohol, it's pretty good. Well,
you certainly earned it. So for the folks that attended the 250th dinner and the annual members meeting, a lot of the presentations you saw, the music, all the in-between stuff was at the hands of my esteemed co-host across the thing. So as a thank you, I said, why not, a little bottle of something.
I appreciate that.
But this is the Heaven Hill Bottled and Bond. So Bottled and Bond is an interesting thing that you see across the bourbon world. So we're kind of taking a dive out of our normal, but if you are shopping for a gift, I know we're like post Father's Day, but the 4th of July is coming up, and you never know if you're looking for this stuff.
Birthday, Christmas.
Bourbon's very popular. When something says bottled and bond, what that means is there are certain criterias to qualify as that. So
it's regulatory. It has to do with like back in the 1800s when they were adding adulterants to whiskey, as I recall. So they passed this law in like the late 1800s.
Not just adulterants, but someone would slap a premium label on some rock gut whiskey and say, oh no, this is really this is higher end brand. It was a way of ensuring that the product you are buying, it doesn't necessarily mean it's going to be good. It's not an indicator of quality in the sense of like, this is going to be better than a non, but
right, but it follows these basic standards.
Yeah, so it was a way of knowing that you are getting the product that you paid for. But yeah, it's a really nice, like 7-year-old. It's a really great bourbon for folks who are not super into bourbons and want something that's like approachable, that you can kind of get into it.
It does pretty good job. And like you said earlier, it's not like a punch in the throat. So
yeah, and it's not, you don't feel like you're making a financial decision buying it. So if you ever dive down the bourbon aisle and you see the locked case and you start seeing commas and price tags and stuff, now this is in like the $50 to $60 range. So
it's pretty good.
It ain't too bad on the wallet either.
Right on.
But there you go. So a little deviation from our normal routine there.
But anyway, turning back to topic, Scott Hayes. Scott Hayes, you remember this guy? We covered this last year, the 2024 shooting incident in Newton. The licensed gun owner from Framingham by the name of Scott Hayes was arrested for defending himself after he was attacked and tackled to the ground by a pro-Palestine counter-protester, right, at a street protest then. That's right. He was the one who was attacked. He stayed on the scene. He administered first aid. He waited for law enforcement, and he was the one who was ultimately arrested. He ended up charged with assault with a dangerous weapon and even a civil rights violation for allegedly shooting the counter-protester in self-defense.
Now, 2025, so this is 9 months of dragging the guy through court.
Yep.
Middlesex District Attorney's Office offered Hayes pretrial probation. So the regular translation of that is, we don't want to admit he was right, but we don't want to admit we were wrong either. So
pretty typical for Massachusetts. Yeah.
Pretty much they had a losing case, I think, on their hand. But under the agreement, what Hayes is required to do is stay on probation until mid-September of this year. He has to stay out of Newton unless he's going to church or the doctor. So you don't have to go home, but you can't stay here. He has to complete. This is just.
I don't even know what this means.
It's so 1984 to me, like the book.
Yeah.
But he has to complete an online civil discourse class.
What does that even mean? And yeah, right.
I don't know.
And civil, online civil discourse.
Your freedom of speech only goes so far as unless somebody gets upset and attacks you, I guess.
Right. How not to, how to de-escalate when somebody physically attacks you, I guess.
Yep, he has to be actively seeking employment. And they have like minimum requirements for how many jobs he needs to seek out a week.
Is he on parole?
And obviously, and then the no contact with the other person,
That one should be pretty easy. I wouldn't want to contact that guy either.
But it's not a plea. It's not an admission of guilt. And if Hayes complies and completes the program that they've laid out for him, the charges will vanish, and the district attorney gets to walk away without a career version of a black eye for trying a clear case of self-defense.
So we'll keep following the case. For now, Scott Hayes walks free, but on a leash. His date is September 13th. That's kind of his finish line. I mean, I kind of hope it's the end of a case that really should never have begun to begin with. What I don't know is what impact it's going to have on his gun rights. It's going to be a suitability issue in Framingham, I would assume. I don't know. I mean, I'm totally speculating way out of the blue. He's not going to have criminal charges, presuming that he goes through with this. He won't have any criminal charges, but he's still going to have to cop to it.
But when he fills out the application for a license for renewal on question number 4,
exactly,
when it says, have you ever appeared in court as a defendant? He's going to have to answer yes.
Yeah.
And it's going to have to reopen all of these things.
The whole case every time he goes for an LTC renewal. It's baloney.
It's terrifying. It's a chilling effect because when you look at it from the perspective of self-defense, he did all of the things that most firearms owners believe is the right thing to do.
Yeah.
He was attacked. He was on the ground with a person on top of him who was trying to reach for his firearm.
He responded. He
used force. Until the threat that he was using the force against stopped.
Yeah.
Then he rendered aid to that individual.
Called law enforcement, called aid.
Did the whole thing.
Things. Yeah, and waited for law enforcement, all those things, and yet he was charged.
And he is the one that is bearing the burden of the punishment when he didn't instigate it. He didn't ask for it.
Yeah, he was just protesting.
He did what he had to do to keep himself safe and then tried to keep even the person who attacked him safe. So
it really should never have been a case at all. So things are going on down in your neck of the woods.
Yes,
I don't know why you're not doing your job down there.
Going south of the border.
Things straight, south of the border.
Well, Rhode Island is trying their own version of an assault weapons ban, and I always put the air quotes around that because it's just a made up. It's completely fabricated term.
Of course.
But that is the name of it. So Rhode Island is trying their version of an assault weapons ban coming soon, and it's possibly worse than Massachusetts, if you can believe it or not. The Rhode Island House of Representatives recently passed H. 5436, the Rhode Island Assault Weapons Ban Act of 2025, in a 43-28 vote. All 10 Republicans, 17 Democrats, and 1 independent voted against the bill. The key provisions here is it targets semi-automatic shotguns with fixed magazines over 6 rounds, semi-automatic rifles with detachable magazines, and rifles with features such as barrel shrouds. It specifically cites shrouds that are designed to prevent the operator from being burned.
How dare you have a gun that doesn't burn you?
Threaded barrels, pistol grips. So a lot of the same things that we're accustomed to seeing, but specifically the semi-automatic shotguns with fixed magazines over 6 rounds. It also bans parts that can be, and I put the air quotes around it, readily assembled into a, air quotes, assault weapon.
What the hell does that mean? Does that mean I can't buy an AR stock?
If they...
A fixed stock or...
it is impossible to understand or know, because what Rhode Island has done is they've tried to parrot the Massachusetts language, and we know the Massachusetts language was written by people who know nothing about firearms.
Right.
So you're 3 or 4 people removed now, where there's no clue.
It's like that game of telephone, right, where you whisper down the line, and by the time it gets to the people in Rhode Island, they make it as trashy as Massachusetts, and they're like, yeah, let's crank it up one more notch.
Yeah, go to Google Translate and just translate it from one
English
language to another language to another, and then back to English. But it also goes into other definitions. So it redefines what a detachable magazine is, defined as any magazine that can be removed even with a tool or other object.
So every magazine
Yes.
ever.
If it can be removed easily with a tool, with an object that's used as a tool.
Even fixed magazine firearms, even integral magazine firearms, because you can remove them with a tool.
Yep.
Wow.
They are, amazingly enough, even though they didn't originally do this with magazines, offering a grandfathering and registration option. So firearms that would now be covered under this bill that were legally owned before enactment, which is scheduled for January 1st, 2026, if it passes, would require the person to register that firearm. So submission of a registration form with name, address, date of birth, driver's license, or ID, the firearms details, make, model, caliber, serial number, all the good details. You need to submit fingerprints for an additional background check, a $25 registration fee per person. I think it just means the owner. So if you have, 5 different firearms, I believe it's only one fee, but you still have to do 5 forms.
Yeah.
They did not clarify whether someone else in your household who may have access to those firearms, do they have to register it to themselves as well?
Oh, yeah.
But you also need to submit a signed statement under penalty of perjury affirming the information's accuracy. So make sure there's no typos or you don't accidentally transpose any numbers, because that will be a crime.
Yet another paperwork
to make a
crime.
mistake. Once registered, the owner will receive a certificate of possession, which you must then share with your local police department, the Rhode Island State Police, and the State Attorney General. Registered firearms under this grandfathering provision cannot be sold or transferred, even through a licensed dealer. And upon the owner's death, they may only be inherited by a direct heir who then must register the firearm to themselves within 90 days.
Jesus.
So if not inherited or transferred out of state via an FFL, owners must surrender their firearms to law enforcement, sell it to an FFL for out-of-state transfer, permanently disable it, aka destroy it, and submit a sworn certificate detailing the firearms information and date of inoperability.
Oh, come on.
In order to stay legal. Now, its companion bill, S359, in the Rhode Island State Senate is under review currently by the Senate Judiciary Committee. Sponsored by 10 senators, it faces surprisingly some internal opposition. 3 Democratic committee members opposed it during the initial hearing, and a 4th voted against similar bills in the past. So of that group, there are people who push back.
Yeah, but because they're pro-gun rights, or because they're like, this is so bad, we're going to get our asses handed to us?
More on the pro-firearm side than you think.
Oh, yeah? Okay.
But Senate Majority Leader Frank Chacon is a licensed firearms dealer himself, and he has expressed opposition to the bill as it's currently drafted. He had it in the as drafted thing. I don't know why he needed to add that in, but technically he did add it in. His Senate...
That's him saying, if we make changes, I'll support it.
Maybe. I don't know. But he seemed rather opposed to it. His Senate position, though, means he serves ex officio on all committees, which bill supporters pounced on to claim he must now have a conflict of interest. Chacon responded by proactively seeking guidance from the Rhode Island Ethics Commission, which determined no conflict exists. He's totally fine to participate in discussions and votes because he would not be affected any more or less than any other FFL in the state.
Yikes.
So imagine that, like someone saying that because a politician would be impacted by a law, they aren't allowed to speak on it. Yeah. Which I think kind of tips the cap to the default assumption in their mind is that when they pass laws, they don't have to follow them. So So in a bit of a controversial move, Senate President Valerie Lawson, a co-sponsor of the bill, declined a request by fellow Democrats to reassign the bill from the Judiciary Committee, which is believed to be deadlocked on this, to the Senate Finance Committee, where proponents of the bill thinks it has a better chance of passing. They argue Senate rules require the president to honor that request unless someone else objects, which would trigger then a full Senate vote. Yeah. However, Senate Minority Leader Jessica Dela Cruz pointed to the rules stating that bills that involve criminal penalties must go through the judiciary. So
interesting.
Her refusal to shift a co-sponsored bill has sparked a little bit of internal criticism.
Signed onto it, and she obviously wants it to pass, or she wouldn't have signed onto it. And yet she's from a procedural standpoint preventing it basically from going to a committee from which it would have a better chance to be reported favorably.
Yeah, I mean, with the track record that we've seen in Massachusetts, it is shocking to see a state legislator and someone with that much power follow proper procedure. Given our recent and extensive experience in Massachusetts of lawmakers manipulating and abusing rules and procedures to pass legislation that might not otherwise go through. But the bill remains in play. Debate is continuing over its constitutional implications. The legislative session ends June 30th, so there's not a lot of time to resolve anything.
Oh, yeah. As of this, they've got just under 2 weeks left to get it done.
Yeah. So while firearms owners in Rhode Island may temporarily avoid restrictions if the bill stalls this year, its advocates are expecting to...
Yeah, of course.
Its advocates are expecting to renew efforts and with greater intensity in future sessions. So we'll have to keep an eye on this, especially in light of the U.S. Supreme Court their recent refusals to hear multiple Second Amendment cases.
Yeah, the trend from the Supreme Court's a little disturbing. And the fact that, just like you said, even if it gets shot down this time, they're just going to bring it back next year. Just like some of the nonsense that we have here in Massachusetts, it never fails. When something gets shot down, they just bring it up next time.
Well, then the thought and philosophy would be, and whoever votes against it, they will try to primary out of that position. And the vote against this bill will be used to push those people out.
They voted against common sense gun reform. Yeah. So we'll keep an eye on it. I mean, for people who, if you're out there listening to this, hopefully you're a Goal member. Don't think for a minute that this stuff in Rhode Island doesn't affect you. It does, even though this is technically, south of the border. And not Massachusetts strictly, it's still part of New England. It's still part of the fight that we're fighting here.
Yeah, and if you want to go support that push, the group in Rhode Island is the Rhode Island Second Amendment Coalition.
I hope they're able to get it done. On the national level, the SHORT Act has become part of the so-called Big Beautiful Bill. It kills me to call it this as like a libertarian because there's a lot in Trump's budget reconciliation bill not to like from my perspective. That's kind of outside the scope of this podcast. However, the House has included like we talked about last episode, the House has included suppressors in their version of the budget reconciliation bill. As of very recently, the SHORT Act, or the language of the SHORT Act, has been added to the Senate version of the budget reconciliation bill.
Yeah, so we're looking at 1,196 pages for the House version alone.
Yeah, it's crazy, right?
But what they're looking at is repealing the $200 NFA transfer tax on suppressors. That's part of the House side with the suppressor stuff.
Right.
The SHORT Act would remove the $200 transfer tax on all NFA taxes on suppressors, SBRs, or the short barrel rifles, short barrel shotguns, the any other weapons catch-all category.
Right, catch-all category.
So it's not deregulating them, and it's not abolishing the NFA, but it's just saying that you don't have to pay a punitive tax in order to own the thing.
Right, and it would have to be in order to survive like reconciliation. The budget reconciliation process, in order to survive that, it has to do with revenue streams for the federal government. So if the language as written survives reconciliation, these taxes would be repealed, but none of the other provisions of the NFA, like registration and transfer, manufacture, all that stuff is not
still filling out your forms, still doing your paperwork. You're just not having to pay.
Right. If the Senate parliamentarian rules that a provision is non-germane, meaning that it's not primarily about taxing or spending, it could be stripped out of the bill before a floor vote.
Which could be expected if they said, hey, in the budget bill, we're going to remove the NFA, or we're going to delist or deregulate this stuff.
Right.
That could be considered not germane. But this really is just approaching a taxation issue, which does fall under the scope of budgetary items.
Yeah, I'm cautiously optimistic about it. There's a lot to dislike about the bill as a whole, right? Like I said, but that's outside the scope of this. This one piece, if it survives, it could be like the biggest rollback of NFA taxes in 90 years, right? Since the institution of the NFA. Which
it should be a no-brainer. But the big question is okay, so they roll it out of this tax. This bill could roll back that tax payment,
right,
for the thing. But doesn't that mean that next budget, next administration, the pendulum swings the other way? They go, actually, we're going to reinstate that tax and we're going to tack on whatever else.
Yeah, that's exactly the question. And I've come across this question and I've been asked this question. The answer is yes, and probably not easily. The trick here is the Senate parliamentarian, like I said before, and what's known as the Byrd rule. This rule requires that any provision of a budget reconciliation has to have a direct impact on federal revenue. The argument for repealing the tax fits a little bit better with this rule than reimposing it later on would. Okay, and this is my argument, my interpretation. Repealing the NFA tax, in my opinion, fits the rule pretty clearly. It's obviously a measurable reduction in federal income tax, right? Federal income revenue. Reimposing the tax, though, is a little bit different. That's essentially creating a new tax, because once it's repealed, if you want to bring it back, it's the same as, imposing a new tax. And it's a new tax that doesn't have a new program. It doesn't have new spending or anything else behind it. It's just saying, pay us more because reasons, right? It's also a narrow tax on a small niche group of Americans, something that appears punitive and looks like regulation by taxation, which is just the kind of thing that the Byrd rule is supposed to be designed to weed out. So,
yeah, the spirit and the intent is to say, if you wanted to write a law to ban something and you couldn't get it done,
right,
this would have been a path to say, well, we'll just tax it to the point where it's so completely unaffordable, right, it's like de facto banned. It's banned by this proxy process.
Exactly. So could an anti-gun Congress in the future take a shot at it? Of course they could, if they have a supermajority and if the cards fall just the right way, but it's also politically risky. Cutting taxes in general is almost universally popular. Instituting new taxes, which is what it would be, goes against kind of like the political gravity, and it requires you to burn political capital. It may not be worth it to future Congresses, especially for such a small revenue stream, right? You're not going to be closing the budget deficit with suppressor stamps. So the bottom line for me is that repealing a tax through reconciliation process, which is what this is easier than bringing in a new one by the same reconciliation process. If this current provision passes the Senate parliamentary scrutiny and it survives in order to become law, it's a small win, but small wins like this tend to be sticky. So we'll see.
Also from the federal side, so the Department of Justice, I don't know if you read this, made a really pointed statement.
I did.
About Illinois and its firearms and magazine bans, specifically stating that it is the position of the Department of Justice that it violates the Second Amendment. So DOJ under, Pam Bondi and the Trump administration, all the people, filed an amicus brief in the Seventh Circuit Court of Appeals. The Seventh Circuit covers Wisconsin, Illinois, and Indiana. They're challenging Illinois' ban on commonly owned semi-automatic firearms and magazines that hold more than 10 rounds, arguing that it violates the Second Amendment. So the key argument, the DOJ wants the appellate court to reverse its prior decisions and support a U.S. District Judge Stephen McGlynn's preliminary injunction, which blocked the ban. So ban goes in place. McGlynn issues the preliminary injunction. Appellate court says, no, we're not going to go with the preliminary injunction. We're going to reverse that.
Okay.
The Department of Justice says, no. Preliminary injunctions should stay. Now, the constitutional question, The brief emphasizes that the Second Amendment's prefatory clause, the one that the anti-gun people love to use.
Right. A well-regulated militia being necessary to the security of a free state.
They're saying that that does not limit the operative clause. The right of the people to keep and bear arms shall not be infringed. So citing Heller, the DOJ argues the Constitution requires a logical connection between the stated purpose and the command. Therefore, the government can't just ban firearms because they're, put the bunny quotes around it, militaristic. That kind of logic would basically ignore the very reason the militia is mentioned in the first place. So the bottom line for the Department of Justice is just because a firearm is used in rare, albeit tragic incidents, doesn't mean it loses protection under the Constitution. If a gun is commonly owned and lawfully used by millions of Americans, it remains a protected arm, plain and simple.
It seems pretty, pretty clear cut to me.
It's an interesting argument because it really takes a shot at the piece of the Second Amendment that people love to grab onto to say no, we are talking about
a well-regulated militia. Regulation means regulation, and it means
whatever they want it to mean. Right. The regulations that they see fit. Right. The Department of Justice is saying absolutely not. And
Heller was clear about it. Yeah, like you said. Very interesting, very solid brief from the Department of Justice. It is really, I've been very, very skeptical of the administration and the Department of Justice, and it's nice to see them actually putting pen to paper in a meaningful way and not just for headlines. It's out of character. The DOJ, I'm pretty sure this is the first it has to be among the first, if not the first time that the Department of Justice has stepped up to intervene in a case like this at this level.
For the Second Amendment, yeah.
Yeah. They have a long history of not getting involved in this kind of stuff, and it's good to see them take a positive stand on it.
Yeah, so we'll have to see how that continues. I think it is very much teeing up, what we saw from the Supreme Court for the last year, few years, combined with this and other cases. It really is teeing up the Supreme Court to tackle the challenge and tackle the question of the handful of states that like to put in, arbitrary bans on specific firearms because, black gun is scary to them.
Yeah. Ban, ban, ban. Ban, 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 ban.
But the Supreme Court has been busy elsewhere.
Yes, they have. So the Supreme Court has blocked Mexico's lawsuit against U.S. gunmakers. We've covered this kind of in depth from the beginning because it was filed in Massachusetts federal court.
And of course they accepted it.
Of course they did because it was Massachusetts. Last week, as we record this, the Supreme Court issued a major ruling in Smith & Wesson versus Mexico, a case testing whether American gun makers can be held liable for crimes committed by cartels in another country. The decision, unanimous, 9-0. Not a single Supreme Court justice took debate.
Didn't they learn after Catano? Just,
they got the slap down.
Ruling based on your ideology is a bad way to have a balanced and fair justice system.
Exactly. So let's take a look at what happened and what the court's really saying about responsibility and the way that I see it, the rule of law. So the backstory, as we know, the government of Mexico filed suit in U.S. federal court accusing 7 American gun manufacturers, including, of course, Smith & Wesson, of aiding and abetting the flow of firearms into Mexico to their drug cartels. They didn't allege that these companies directly broke any U.S. laws. Instead, they claim that the manufacturers turned a blind eye to shady dealers and marketed firearms in ways that supposedly appeal to criminals. We've seen this tactic before with like cigarette ads and like non-diet soda drinks. It's their deceptive marketing practices. They're marketing to kids, or they're marketing to bad guys, or
when you watch the old like Flintstone Winston cigarette ads, you can buy it. I can see where they're coming from. When was the last time you were watching the Super Bowl or Late Night with Jimmy Kimmel and they broke and went to a commercial for Ruger pistols?
Yeah.
So thanks to our sponsor, Daniel Defense.
And here's a word
to the extent that Daniel Defense wanted to run a Super Bowl ad and they wouldn't let him. They got denied.
Right. That's right. They got shut down.
So who are they advertising to?
So the basic argument in federal court boils down to this. You should have known that your products might get trafficked into Mexico and misused by criminals. You should have known. Enter the PLCAA, the Protection of Lawful Commerce and Arms Act. Congress passed this law in 2005 for exactly this kind of nonsense. The goal was to shut down politically motivated lawsuits that are designed to bankrupt designed to bankrupt gun makers for the actions of criminals. Under the PLCAA, you can't sue a gun maker just because somebody misused a gun that they built. Just like you can't sue Ford or Chevy for people who drive drunk. Makes sense, right? Product liability is supposed to be actual product liability on the part of the manufacturer, not when somebody buys something and then uses it for a criminal act.
Yes. And for the folks that say PLCAA and firearms manufacturers are the only company that are immune from lawsuits.
Protection. That is not true.
Not only is it not true, but there are certainly other companies that enjoy much further and deeper protections than firearms manufacturers do. Yeah. But they're still liable for building an unsafe product in the sense of like false advertising and
unsafe products, I won't name any names, but there's still recalls, still all
and there are exceptions. So if a firearms manufacturer knowingly violates a firearms law, then that case can move forward. And we've seen that happen.
This is an exception that's actually written into the PLCAA. So not only does it, not cover product liability stuff, it says explicitly that if you do this, you're still liable for.
Yes. If the manufacturer breaks the law, they get in trouble.
Yeah, just like every other manufacturer of literally every other product in the United States. So what we're talking about here is what's called the predicate exception. Yes.
Yeah, but Mexico tried to take that and just stretch it
beyond the snapping point of by arguing that the U.S. manufacturers aided and abetted gun law violations by others, and Mexico claimed that these criminals were U.S.-based gun dealers who acted illegally. Supreme Court didn't buy it. So Justice Elena Kagan, you heard me right, Justice Elena Kagan, writing for the court, laid it out plainly. In order to invoke the predicate exception, you have to show that the manufacturer took clear affirmative steps to help somebody break the law, not that they just, made a product that somebody else later abused for criminal purposes. So,
the amount of times the justices who typically vote against Second Amendment issues say the thing out loud.
Yeah.
There's a part of me that's like, as soon as you take a case, you have everything laid out right in front of you.
Yeah. Yeah. Right. They go out of their way to make sure that that's true. They're like, they don't get involved in interlocutory decisions, much to our dismay. They're like, we want to make sure that all the facts are laid out first.
But Kagan's done it.
Yeah.
Kavanaugh did it in the most recent one.
That's right.
They all keep admitting and laying out that the firearms at hand are popular. They are not
common use.
They're in common use. They're not uniquely dangerous beyond any other firearm.
Yeah. So Mexico's lawsuit did not meet the standard that Justice Kagan laid out. It's not even close. There's no specific dealers named in the lawsuit. There's no concrete violations alleged, and there's no direct connection between the gun makers and any criminal act. So they're suing because of why? Why are they suing? For the hell of it. It's just a lot of like hand waving and marketing practices and bad vibes. And, we don't like gun makers, so we're going to say that they're marketing to bad guys. The court pointed out clearly that there's a big difference between knowing something bad might happen and actually helping it happen. Just knowing that some dealers might break the law isn't by itself enough. The court said Mexico's complaint was too vague, and it was too vague. They named no charges, no dealers, no concrete examples, and they demonstrated no link between the gun makers' actions and any illegal sales.
I mean, otherwise you can sue every bank in the world for having money that somebody wants to rob.
Well, yeah.
But Kagan also warned that if courts allowed that kind of legal stretch, this kind of predicate exception would effectively swallow the entire PLCAA. So anytime a firearm was misused, intentionally misused, the industry would be dragged into court over and over for something that it had no role in doing. And that's exactly the abuse the PLCAA was written to prevent.
Exactly. So now the sort of 30,000 foot view, the big view, the case was, to my mind, never really about guns. It was about legal responsibility, right? Do we hold manufacturers liable for unlawful acts of other people? I say no. Just like, the allusion to, Ford and Chevy and driving drunk with their vehicles. And the court agrees. No, not unless there's a clear legal violation and active participation. That protects not just gun makers, but, by extension, all manufacturers from lawsuits that are based on what somebody else did with their product. We build a product, we sell the product. Once you have it, if you choose to do something illegal with it, that's on you.
Yeah, I'm pretty
straightforward.
Pretty sure Dick's Sporting Goods doesn't want to go to court every time someone gets hit with a baseball bat.
Right. So whatever the real motivations for Mexico's lawsuits, and I have my own opinions on the matter, whether this was filed in good faith or as a political move to end run around the PLCAA, concerns about gun violence, let's face it, they're real. The Supreme Court, however, made it clear in this case that holding manufacturers liable for downstream misuse isn't something that courts can just invent. The Supreme Court reinforced a pretty simple but powerful principle, which is we don't punish companies for crimes they didn't commit and for crimes they didn't help commit. Responsibility matters, and that's, to me, that's like the bottom line of the rule of law.
Now, what I would like to see, and I don't know if this exists as a practice, and if it doesn't, it should, for all the judges and justices that accept this kind of nonsense, that get overturned unanimously by the Supreme Court, where you have, of all people, Elena Kagan making a pro-Second Amendment argument.
That should tell you something.
That's got to be a ding on your record like you read about. It blows my mind that someone can be that bad at their job to have this be the result, and they get to continue making decisions.
It's like your anti-gun finding was so bad that even Elena Kagan. We also had a brief piece of news out of the federal government with regards to restructuring the ATF. Read about this. So, Justice Department is making a proposition to combine, and it looks like it's going to happen. The two agencies, the DEA and the ATF, are going to be combined under the same agency. And there's been a little bit of FUD and noise and a little bit of hand waving about this.
The DATF. I mean, where are they going with this?
I don't know where the hell they're going with it, but it's part of this push by the Trump administration to reshape the federal government. The agencies are supposed to develop plans for eliminating employee positions, consolidate programs, things like that. But merging the DEA and the ATF is getting a lot of pushback, at the ground level, because they're concerned about having this massive budget for enforcement, and they're worried that this is going to create some massive conglomerate, 3-letter agency that's going to overbear everything.
Well, that already exists. It's called the DOJ. So,
well, fair enough.
So,
that's fair enough.
Okay, so the divisions are merging into something else. I'm not as terribly concerned about it.
Yeah.
Presumably, you can save some money by having fewer accountants and administrators, maybe. But
yeah, I don't know how it's gonna shape out. I mean, I obviously, if you listen to me at all, I'm a pretty small government guy. I'd like to see both of these agencies disappear, but I'm a little concerned about it, I guess, from a regulatory agency bloat standpoint. But then again, maybe it's a lot of FUD about nothing. The ATF and the DEA have different missions. So I don't know how much overlap there's going to be putting them under the same department.
Well, I mean, the alcohol and tobacco part is certainly one aspect of it. But drugs and firearms, all that trafficking stuff, all goes hand in hand. So I don't think there's necessarily any issue with them, having some cross-pollination of work and ideas and investigations. I don't think that's necessarily a bad thing. The only thing I would want is that they focus their time, energy, effort, and money into going after violent criminals instead of looking to create more classes of criminals for them to go after.
Yeah, right. And the whole like zero tolerance, which thankfully has been repealed, but like the whole zero tolerance, paperwork crimes. It's stupid to prosecute paperwork crimes when they should be going after actual violent criminals, like you said. I don't know. We'll see what happens with it, I guess.
But some administrative consolidation, it all falls under the umbrella of the Department of Justice anyway. So I don't think it's necessarily as big of a deal to say like, well, they're creating a super agency when it all kind of falls under the same umbrella.
Well, anyway. to a certain degree, but yeah, you're not wrong. You're not wrong. So we have, that's kind of a lot of, small topics. There's a lot going on, but it's like a lot of smaller topics. So we'll keep an eye on all of this stuff, and we'll have more developments on the Massachusetts front as we move into the summer. So we're looking forward to developments. In the meantime, though, that's going to do it for today. Thanks for listening in. Be sure to subscribe to the Goal Podcast and check us out on Facebook at facebook.com/Goal Podcast MA, on YouTube at the Goal Podcast, or on Twitter at Goal Update.
To join Goal, visit goal.org and click the Join Renew button on the top of the homepage.
If you have a topic you think we should cover, if there's something going on in your club or town, or if you have a question for the mailbag, shoot us an email at goalpodcast@goal.org.
The Goal Podcast is a production of Gun Owners Action League of Massachusetts. The views and opinions expressed are those of the hosts and guests and do not necessarily reflect those of Goal, its staff, or affiliates.